Quite frankly, the offense Mr. Dunn committed here in 2024, no, I think it happened in 2025, sorry, 2025 is almost exactly the same as what happened in 2000. The parallels, the similarities are shocking. The foreign connection, the picking it up, the redistributing large amounts of it to other people, and then not my business what they do with it, it's the same. He got 10 years prison for that back in 2000, and he's doing it again here, the exact same thing, using foreign connections to get a drug pipeline and making himself into a fire hose of methamphetamine into the community, 1,000 grams at a time. We caught him here with 100, and the CI bought 1 gram, a mere fraction of what he described to the police. Fact is, Michael Dent is a drug dealer. We know that because he's got the past conviction and the present conviction. And worse than that, what he describes as beyond that, it's really being a drug trafficker, being that middleman connection between a larger wholesaler and smaller distributors in the local community. That's his history. That's what he did here. The 10 years prisons didn't deter him. It didn't stop him. He just moved to Burnett County from Waseca instead. I think a sentence of less than 10 years initial confinement here would unduly depreciate the seriousness of this offense because of that past conviction. If we did the same punishment or less punishment for the same or similar behavior, then what message are we really sending to Mr. Den, to the community? It defies principles of proportionality. It defies McCleary-Gallion. It has to be more. That's how specific deterrence works. You ratchet up, you don't ratchet down. The repetitiveness of the facts and the offense also demonstrate to me a need for long incarceration for both incapacitation and public protection reasons. If deterrence is not going to work, if 10 years prison didn't work in 2000, then we have reason to believe that it might not work again here, no matter how much. He might come back and do it again. He still has the same connection. He could always open up shop again. He could move to a different county or just stay here and do it the same. That's why any year incarceration this court orders might save the community potentially hundreds or thousands of grams of methamphetamine coming into it. That's a lot of hurt and pain and suffering and potential death that could be stopped from coming here, all while Mr. Den is in custody, while he's in prison. That's the incapacitation angle. And that's time the community can be protected. I think incapacitation and public protection are really elevated in this case above the other principles we sometimes use in these cases involving controlled substances, just because of the volume and the past history. There's another reason why I think those are elevated here, and that really has to do with the defendant's overall recitation of his history. When you go through in the PSI him describing his past convictions, I think there's cause to be concerned. He's not a great target of rehabilitation and specific deterrence, because when you have an offender who seemingly either can't remember much detail about their past criminal convictions that have resulted in quite a bit of jail or prison, or they recite their past criminal history as though, I had a minor role, someone else is really at fault, where there's deflection, where someone's really to blame, then you have reason to believe that the person's not susceptible to specific deterrence or rehabilitation. Those things only happen. Rehabilitation, specific deterrence only really happen when a person is affected by their own actions through guilt or consciousness or morality or the effect of the sentence itself. The 10-year sentence didn't stop the behavior here. And when you see a person recite, either don't remember or somebody else was the main one at fault, it says they don't really have a lot of insight to their own situation. If there's deflection of blame, then that's someone, we use the broader term accountability or taking responsibility. Those have certain moral implications, but beyond that, if a person doesn't think they did something wrong, if they think it was someone else, or if it affected them so little they can't even remember it, that says that something is happening inside them, that they're not effectuating behavior change either. So there's a bigger reason to be concerned about that, in that, is this going to be another case like the past ones where it's not going to affect behavioral change because someone else is responsible, or it's not going to affect him all that much because whatever reason. And we see a little bit of that even already for this case, where Mr. Den clearly tries to say the CI planted half of the drugs, and then the other half, which was an enormous amount of drugs, was still just for personal use quantity. We're talking quantities of 40 to, one of them was between 40 and 50, and the other was over 50, is my recollection. If the court has paused to believe that Mr. Den is likely to rehabilitate or to be specifically deterred by the sentence because of these factors, that would be more reason to, when you're balancing the different factors that it has to weigh more in the incapacitation side, more in the public protection side. And I think this is one of those cases. If a person tells you who they are, we should really be listening. And if a person tells us, you know, even after being to prison for 10 years for being involved in large methamphetamine distribution and doing it again, that I don't recall other things, or really I'm being framed by the CI, that should cause the court concern. I think Michael Den has told the court who he is.
You're saying, I mean,
I can't hear him very well. I don't
we have
Can't hear. We do have hearing devices, and we will have Olivia, she'll hook you up. And I can turn the system up a little bit without it screeching.
Thank you.
Testing. Can you hear me?
Yep.
Yep.
Perfect.
Okay, so he can hear now. So Mr. Schmidt, you may continue.
Sure. I think that Michael Den has told the court who he is, both through his actions and his words. For the second time in this century, he has used foreign connections to secure large amounts of methamphetamine and distributed them into the community. If not directly by himself, by taking the large wholesale amounts and giving them to other people, he knows what they're doing with them. He knows what a person does with hundreds of grams of methamphetamine. He takes no moral responsibility for that. I noticed that when he was talking about his the California connection one, the Waseca one. I don't know what they were doing with that. Yes, he pled guilty to reduced charges, but the facts of what he did are not changed. And his history is massively aggravating. If 10 years prison wasn't enough in 2000, we should be trying 15 now. He is statutorily ineligible for CIP because of his age. I think the court should make him ineligible for the ERP entirely here because of the past 10-year conviction. I think the threat of Mr. Den does not derive from his substance abuse disorder. I think it's his connections and his ability to procure large amounts of methamphetamine, much larger than many people are able to get for himself and others. I think that for the protection of the community, the court has to act here and they have to stop Mr. Den. That should be the purpose of this sentence. First and foremost, to stop Michael Den. Second, to specifically deter him with a larger sentence than the last one he got for really the same behavior. Thank you.
Thank you. Mr. Keem?
yes, Your Honor. I'm just going to start with the basics. When you look at the gravity of the offense, what I think about is drug offenses tend to differ from a lot of the other ones. We look at the gravity. You know, for example, if you look at someone committing a robbery or an assault, or in worst cases, a murder, homicide, they aren't usually someone who's necessarily suffering from the same crimes, the same effect that we're trying to solve. For example, the reason we have drug laws is to stop people from using drugs on their own and harming themselves. And Mr. Den, when he talked about his past use and his use here, you know, he was a heavy personal user. And in this case, he, sold a amount for the informant, mainly for his own habit. And, the one thing that's sort of mitigating about the offense is that generally people who look for drugs, they find them. It's not, it's very rare that someone who, uses and or deals drugs just goes up to random people in the community. Hey, you want some meth? I mean, it's sort of the drug use element. It's sort of a self-selecting community. And I'm not saying that they're in control of their actions because, almost no one who's in control of themselves would, choose the life of being a meth addict or heroin addict or any other drug, because you see the DACs, I see, we all see what happens when people get hooked. And it's, some people are able to casually use it, but it's a hard line and it's a pretty steep fall.
All right, let's talk about that. The sentencing hearing for State of Wisconsin v. Michael Den took a hard turn into the deep end of aggravating factors, with District Attorney Kevin Schmidt laying out a detailed case for why Den's punishment needed to exceed anything he'd seen before. This wasn't just about the quantity of methamphetamine, though. The amounts were substantial. It was about the striking parallels between this case in 2025 and one from back in 2000. Schmidt painted the picture of a man who, despite serving a decade in prison for a nearly identical offense, had returned to the same behavior. Using foreign connections to secure wholesale quantities of methamphetamine and redistributing them into the community. The DA emphasized the sheer scale of Den's operation, describing him as a fire hose of methamphetamine, moving product in 1,000-gram lots. The controlled buy in this case involved only 1 gram, just a drop in the bucket compared to the 100 grams recovered in the search and the kilo-level purchases Den admitted to police. Schmidt's core argument was proportionality. If 10 years behind bars didn't deter him before, giving the same or less now would defy principles of proportionality and send the wrong message to both Den and the community. Specific deterrence, he argued, meant ratcheting up, not down. But this wasn't just about the past and the present, it was about Den's mindset. Schmidt dug into the pre-sentence investigation, noting how Den either couldn't recall details of prior convictions or minimized his role, blaming others. This deflection, in the DA's view, was a flashing warning sign that Den wasn't a good candidate for rehabilitation. Schmidt even highlighted Den's claim that a confidential informant planted half the drugs found in this case, while suggesting the remaining large amounts were just for personal use. For the court, he argued, this was the kind of denial that warranted prioritizing incapacitation and public protection over hopes of reform. He urged the judge to consider a 15-year sentence and to deny eligibility for early release programming altogether. Defense attorney Glenn Keene's approach was different, slower paced, measured, and aimed at reframing the gravity of the offense. He acknowledged Den's heavy personal use, framing the sale to the informant as something driven by habit more than enterprise. He noted that drug use tends to exist in self-selecting circles, not random predation on the community. It wasn't an attempt to excuse the conduct, but to put it in a different context, one that sees addiction as part of the equation. Keene also pointed out the rarity of casual, consequence-free use and the steep decline for those who become dependent, suggesting that Den's circumstances weren't unusual in that regard. Judge Mogen kept control of the room throughout, pausing when Den had difficulty hearing to ensure he was hooked up with assistive listening equipment before the DA continued. That moment, simple as it was, showed her usual attention to due process and making sure every participant could fully engage. The overall tone in the courtroom was serious but steady, with no raised voices or heated interruptions, just two very different sentencing narratives presented for the court's consideration. By the close of arguments, it was clear this case wasn't going to be about leniency. The state's push for a longer sentence rested on history, scale, and mindset, while the defense's softer framing hinged on the role addiction played in Den's actions. Judge Mogen now had to decide how much weight to give each and how much time would truly serve the purposes of protection, deterrence, and justice. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.